We are very fortunate to have Mr. Jeffrey Deskovic, who is joining us today. A good friend of mine. For some of you that don't know, I do work as a filmmaker, and Jeff has been a producer and a huge supporter of that, and likewise for his foundation and the work that he does. So it just happened to time out that he was making his way to San Diego for a conference, and he flew into LAX. So really thank you for squeezing this in. And obviously he's a man that can bounce back, not just from his story, but as you just saw. So good stuff. So I'm going to read a quick introduction. At age 17, despite a negative DNA test, Jeff was wrongfully convicted of a murder and rape which he did not commit. After losing all 7 of his appeals and being turned down for parole, in the 16th year of his sentence, which was in 2006, Jeff was exonerated with the help of the Innocence Project. Further DNA testing via the DNA databank not only reaffirmed his innocence, but also identified the actual perpetrator, who was serving time for having killed a mother of 2 just a few years after committing the initial crime. Jeff has delivered over 100 presentations across the country. He's authored over 200 articles and given hundreds of print, radio, and television interviews, including multiple appearances on CNN, Al Jazeera America, the New York Times, and the Wall Street Journal. He has lobbied elected officials in New York, Connecticut, and Washington, D.C., and testified at legislative hearings in New York and Connecticut where wrongful conviction prevention legislation was considered. In collaboration with New Yorkers Against the Death Penalty, he helped ward off capital punishment reinstatement efforts in New York, as well as participated in the campaign which legislatively repealed the death penalty in Connecticut, giving presentations and media interviews in key battleground districts. He has conducted numerous seminars at judicial gatherings, bar associations, prosecutorial groups, and other professional associations. Jeff is certified as an instructor in New Jersey, which grants him the ability to present in police academies, and has given numerous presentations to soon-to-be graduating classes of police and correction officers. He co-designed a wrongful conviction college course syllabus which was taught at Farley Dickinson University, and additionally co-taught a wrongful conviction college course at Rockland Community College. Jeff graduated Mercy College with a BA in Behavioral Science, which had awarded him a scholarship, and has a master's degree from the John Jay College of Criminal Justice, which includes a thesis written on the causes of wrongful conviction along with reforms needed to address them. He is listed in John Jay College of Criminal Justice's 50 at 50 book as one of the top 50 standout students in John Jay's 50-year history. In 2014, Jeff won New York One's New Yorker of the Week award, as well as the 2015 Humanitarian of the Year award by the New Rochelle Chamber of Commerce for his advocacy work and dedication to the cause of wrongful conviction. He is the founder and the director of the Jeffrey Deskovic Foundation for Justice, which works to free the wrongfully convicted as well as prevent wrongful conviction by raising awareness and seeking changes in the law to address systemic deficiencies that lead to wrongful convictions in the first place. Jeff is additionally an advisory board member of It Can Happen to You, which is a coalition of nonprofit organizations, Exonerees, the falsely accused, individual advocates, and the general public that come together to work for the prevention of not only wrongful convictions but false accusations. He has just started law school at the Elizabeth Howe School of Law at Pace University. So without further ado, I present you Jeffrey Deskovic.
I have to say, I think that was one of the most dramatic entrances I ever made. In 1989, a classmate of mine was found murdered and raped. Peekskill is a small city with a population of approximately 25,000 people. Murders were very rare. So when this murder happened, understandably created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to the kids in the high school. In the course of the police investigation, the police interviewed many students from the school. Some of those kids told the police that they might want to talk to me because I seemed strange to them. This is what the police said initially attracted them to me. The other factor which they said attracted them to me was that they said that I was overly upset at the victim having been murdered. Yet there were mental health facilities set up all throughout the city of Peekskill offering free mental health services to help people process what had happened. Again, keeping in mind that murders were very rare. So for about 6 weeks, the police played this cat and mouse game with me, in which half the time they would talk to me as if I was a suspect, and the other half the time they would talk to me pretending like they needed my help to solve the crime. They would say things like, "The kids won't talk freely around us, but they will around you. Let us know if you hear any rumors. Stop in from time to time." They would ask me opinion questions and then congratulate me on my opinions being correct. They made me feel important. They made me the center of attention. I came from a single-parent household. My dad was never involved in my life in any aspect, and so that directly interacted with one of the techniques that the police were using, which was the good cop, bad cop routine, which is sometimes referred to as Mutt and Jeff, in which one officer takes on a more aggressive role, yet his partner pretends to be opposed to what's going on, he pretends to be a friend, yet somehow is powerless to intervene. The purpose, of course, of this technique is that when the person being questioned becomes frightened, it's only natural that you would look to a friendly face for assistance. So I began to look up to this officer who was pretending to be my friend, and again keeping in mind the total absence of my father from my life. The other psychological dynamic that was in play was that my fantasy childhood career that I wanted to be when I grew up, my idea of pre-teenage years, because it changed, was actually I wanted to be a cop. So this unexpected early opportunity to do this quasi-police work, along with my age, which was 16 years old, is what allowed the police to pull the wool over my eyes with regards to this absurd fiction that a 16-year-old is going to be able to help solve a murder case with the police. So after about 6 weeks of this, the police told me that there was some new information that had come into the file that they wanted to share with me, and that would put me in position to be of better assistance to them. So help us to help you to help us type of logic was employed. In order for them to share that information with me, however, they said that I would have to take and pass a polygraph test, which is known in other quarters as a lie detector test. So the next day, rather than report to the high school, I instead went to the police station for this test. As I just mentioned, it was a school day, which meant neither my mother nor my grandmother with whom I lived, they didn't have any clue that anything was wrong. As far as they were concerned, I was actually in school, and therefore they did not call around looking for me. They drove me to the town of Brewster, which is in Putnam County, whereas I was a native of Peekskill in Westchester County. And the significance of my sharing that with you is that that meant I was no longer able to leave on my own. I was instead dependent upon the police. They put me in a small room. I did not have an attorney present. I wasn't given anything to eat the entire time that I was there. There were 3 officers that had accompanied me from Peekskill, but then there was also the polygraphist, Putnam County Sheriff's investigator by the name of Daniel Stevens, who was dressed as a civilian and was pretending not to be a cop. So I never knew that he was a police officer, and consequently he never read me my Miranda warnings, because that would have blown his cover. So before beginning the polygraph, he gave me countless cups of coffee. No sooner would I finish one cup than he would have the cup in his hand and have the coffee coming from the pot, and you want another one? You want another one? So he gave me like 6 or 7 cups of coffee, and it's fairly clear in hindsight that the purpose of the coffee was to get me nervous. See, the premise of the polygraph is that when a person tells a lie, they'll become nervous. The nervousness will result in an increased pulse rate, and it's actually the pulse rate which is measured by the machine. But other factors, though, that would lead to an increased pulse rate would also include fear and caffeine. So after finishing the coffee routine, he attached me to the machine, which was fairly heavy, which meant I couldn't get up any longer. And that's when he launched into his third-degree tactics. He invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. As each hour passed, so too did my fear increase in proportion to the time. He kept this routine up for 6.5 to 7 hours. At the end, he made a statement to me. He said, "What do you mean you didn't do it? You just told me through the polygraph test that you did. We just want you to verbally confirm it." So when he said that to me, that really shot my fear through the roof. And it was at that moment that he left the room, and the officer who had been pretending to be my friend, he came in the room and told me that the other officers were going to harm me, but that he was holding them off, but could not do so any longer. You have to help yourself here, you understand? Well, considering that I had maintained my innocence for the previous 6.5 to 7 hours, that meant that I was no longer able to leave. That meant that it was clear to me that they wanted me to confess. When it was added that if I did as I wanted, that not only would they stop what they were doing, but that I could go home afterwards, that I was not going to be arrested. Being young, naive, frightened, 16 years old, not thinking about the long term, just concerned with my safety in the moment. I was in fear of my life because, first of all, I wasn't used to talking and interacting with men. And then on top of that, the manner in which these officers were carrying on, it was really, really frightening. And you'll see when I have the picture in a minute what I looked like at that point. So I was in fear of my life. The fact that I didn't know where I was, and that nobody else knew where I was either, really loomed very large in my mind. So being overwhelmed emotionally and psychologically, and plus there's the push-pull dynamic in play, because on the one hand, the possibility of harm has been introduced, and then on the other hand, he's throwing me this false life preserver, telling me, as I mentioned, that I'm not going to be arrested. I took the out which he offered, and I made up a story based upon information which he had been given to me both that day and the 6 weeks prior to that, as well as certain items that had been into the newspaper. By the end of the interrogation, by the police officer's own testimony, I was curled up into a fetal position on the floor. I was crying uncontrollably. Needless to say, I was arrested. I was charged with a murder and rape. Now, before I went to trial, the results of the DNA test came in from the FBI lab, showing that semen found in the victim did not match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to counter this negative DNA test result, the prosecutor got the medical examiner to commit perjury and fraud. When an autopsy is done, there's audio and written notes which are taken contemporaneously, just as the autopsy is going on and findings are made. And it's all supposed to, the recording of it is supposed to happen all at the same time as a method of ensuring authenticity. So it was only 6 months after doing that initial autopsy, and only after the DNA did not match me, that suddenly, for the first time, the medical examiner claimed that he found medical evidence to show that the victim, a 15-year-old immigrant from Colombia, who had been in the country for about 1.5 years, leading a really sheltered life in which she never went outside unless she was accompanied by her older sister or her parents, that she had been sexually active, which is what opened the door for the prosecutor to argue that it didn't matter that the DNA didn't come from me. That didn't mean I was innocent. It just meant that she had slept with somebody close enough to the murder and rape so as to explain away the DNA. In other words, basically they were willing to trash her reputation in order to wrongfully convict me. Taking it a step further, the prosecutor actually named another youth by name that he claimed had slept with the victim. But he never had a DNA test performed in order to prove that. He didn't even call this other youth as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. At the same time, the public defender that I had was terrible. He never interviewed nor called as a witness my alibi. I was actually playing wiffle ball when the crime happened. He very rarely met with me. When he would meet with me, and I would try to explain to him that I was innocent and what had happened in the interrogation room, he was always shutting me up. I remember one time he told me that he didn't care if I was guilty or innocent. When we got to the trial, when the medical examiner took the stand, it was a really important thing that my attorney tried to discredit him, because his fraud was what really the prosecutor was relying on in order to try to get around the DNA test result. So when it was time for my lawyer to question him, which is called cross-examination, my lawyer stood up in open court and with a big smile on his face, as if him and the medical examiner were great friends from way back in the day, said to him, "You're going to be pleased to know that I don't have a single question for you." My lawyer should have never represented me in the first place because of a conflict of interest, in that this other youth that the prosecution was falsely claiming had slept with the victim was represented not only by another member of legal aid, but specifically by the lawyer who was supposed to be supervising him on my case. That conflict prevented the defense from asking him to give a sample that could be subjected to DNA testing, and it stopped the defense from calling him as a witness. When I spoke about the interrogation a little bit earlier, I wanted to add that the interrogation was not videotaped, it was not audio taped, there was no signed confession, it was just a cop's word. And as a result of that, when we got to court, they were able to leave out the two illegal acts which they had engaged in, which was the threat and the false promise. So I wanted to testify at the pre-trial hearing. Whenever there's a confession that's going to be used as evidence, there's a pre-trial hearing that the court conducts in which the focal point is whether or not these statements have been made voluntarily and whether the person who was in question was read their Miranda warnings. Because if neither of those things is true, then the judge would not allow the evidence to be used. So because this interrogation had not been videotaped and they left those details out, I wanted to take the stand to explain to the judge what had happened. But my lawyer wouldn't allow me to testify at the pre-trial hearing. He told me that he hadn't decided if I was going to testify at the trial or not, and therefore he didn't want to have me under oath testifying about what had happened in the interrogation room, telling me that if he did decide that I was going to take the stand at trial, that the prosecutor could use the prior testimony to question me about it, trying to make it look like I was lying, even if I wasn't. Yeah, but that line of reasoning really didn't make any sense, because first of all, had the judge believed me, then the statements would have been ruled as involuntary, and therefore they would not have been admitted, and lacking that, they had no other evidence, and so there would not have been a trial. But then, even if it really did go badly, I didn't have to take the stand at the trial, and if I didn't, then the statements what I testified to could not have been used. But then when we got to the trial, he wouldn't allow me to testify there either. He told me that it wasn't his job to prove that I was innocent. It was up to the prosecution to prove that I was guilty, and he didn't think that it happened. Well, that might be a legal principle. We say in this country, innocent until proven guilty, but that's not the way that it really works. In reality, if you find yourself charged with a crime that you didn't commit, you have to do everything in your power in order to try to prove that you are innocent, or else you run a risk of possibly being wrongfully convicted. An additional failing of my lawyer was that when we hadn't decided if I was going to go with a jury trial or a bench trial, which is when the judge was the one who makes the verdict, my lawyer came to me one day and told me that the judge went to him off the record and told him to pick a jury because he didn't want to be responsible for finding me not guilty. My lawyer was supposed to put that statement on the record and ask the judge to recuse himself from the case, because a statement like that shows prejudice and suggests that maybe this judge is feeling public pressure, because every time I made a court appearance, it was a major media moment with virtually all the coverage from a guilt presumptive oriented perspective. Add it all up together, I guess it's not too surprising that the jury found me guilty. I'll never forget the day I was found guilty. It felt like I was in some sort of nightmarish alternative reality. Because to my way of thinking, at least up until that point in time, only the guilty were convicted. Yet the jury said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent. And I referenced the DNA to support my contention. He actually told me on the record, maybe you are innocent, conceding that there was a doubt. How could there not have been a doubt? The DNA did not match me. But rather than exercising his discretion and stepping up for justice by overturning the conviction, which he could have done legally by reversing any number of inaccurate rulings he had made against me in the course of the trial, he instead took the easy, politically expedient way out, which was to sentence me to a term of imprisonment of 15 to life. So at this time, there's a few slides I'd like to show. Let's go to the first slide, which is what I look like. That's my mugshot. This is, I'm not the adult there that you see now. Let's go to the next slide. This is what I look like. I'm in the courtroom, and it's been announced that the jury has reached a verdict, but it hasn't been read yet, so I don't know the result. And obviously, I'm praying it goes the right way. Let's go to the next slide. This is what I look like at the sentencing. And let's go to the next slide. This is what I look like when they sent me to, shortly after I arrived, to Elmira Correctional Facility, which was a men's maximum security prison. I would like to share with you a little bit about my prison experience. I still remember the first day. I remember being in handcuffs and having a chain around my waist and having my legs fastened together, as well as fastened to the legs of the prisoner on the bus next to me. I remember how large the prison wall loomed and how menacing the barbed wire appeared. I don't mind sharing with you that, given my stature and that I was in a men's maximum security prison, that I was really frightened. As I walked down the cell gallery, I saw many prisoners there whose arms were as big as my legs. Didn't take a lot of figuring out to realize that, again, given what I looked like, if any of those people decided to assault me, that I was not going to be able to successfully defend myself. I also had the built-in handicap of knowing that if any of the prisoners there discovered what I was incarcerated for, which was a rape along with that murder, that this would serve as motivation on their part to assault me, because in prison there's a vigilante mentality towards people who have been convicted of sex offenses. The guards themselves were obstacles. To be sure, some were professional and did their job. Yet there were others who brought their frustrations from their personal life into the facility, displacing their frustration onto the prisoners. Then there were other guards who even their peers hated because the manner in which they conducted themselves on a day-to-day basis made it likely that prisoner-to-staff violence could occur that would suck them in, or that maybe a riot potentially could ensue. Yet nobody ever bothered to reel them in. Not their co-workers, nor the people who supposedly were there to supervise them. Then there were the guards who just did their 8 hours and just wanted to do their 8 hours and go home. They didn't care what happened while they were there. While that might sound like an ideal attitude that you want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to literally look the other way and walk in the opposite direction when violence was occurring, so as to be able to avoid breaking things up and having to file paperwork afterwards. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day. There was plenty of violence that did not involve weapons, and there was a lot of gang activity. Taken cumulatively, there was a general atmosphere of violence and adrenaline that permeated the air. In the course of my incarceration, there were various times when I was assaulted, one time in which I nearly lost my life. There was a system of maintaining order in the prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Those sanctions included, and all this would happen simultaneously, you'd be kept in the cell 23 hours a day out of the 24. You could take 2 showers one week and 3 the next, rather than being able to shower daily as the rest of the population. They would send you less food. Sometimes the food would be 3 or 4 days old. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it, if you were lucky. You would not be able to use the phone while you were on that status. The times in which I was assaulted, not only was I have to deal with the physical aspect of that, But then I was also subjected to those sanctions, because as far as the prison is concerned, if you were trying to defend yourself, then that meant you were fighting. In my mid-20s, there were several times where I couldn't bring myself to simply stand there and watch as people I had eaten, drank, and played sports with were assaulted right in front of me out of the clear blue, seemingly for no reason. And so I helped to physically ward off attackers. But then the price that I paid for my ethical decision was that I was subjected to those sanctions. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained the GED, I got an associate's degree, and I completed an additional year of college towards a bachelor's. But then even the silver lining was taken from me, because in 1995, George Pataki became the governor of New York, and he decided that it would be a good idea to cut the funding of college education for prisoners. So when that happened, I started attending the various vocational shops that they had. But although I completed many of the vocational courses and amassed many certificates, it was much better on paper than it was in reality, because the majority of the curriculum that was taught was obsolete 5 years prior to my ever having set foot into the shop. When I was originally wrongfully imprisoned, my mother used to make the 4-hour trip from Peekskill to Elmira. But as the years wore on and the long trip kind of grated on her, and things tightened up a little bit financially, and she began to have a few problems health-wise with regards to her back and her feet, I began to see her less and less, until eventually I was lucky if I saw her once every 6 months. My brother, who's 3.5 years younger than I am, was also impacted by my wrongful conviction. The kids on a school bus and in the school used to tell him that his brother was a rapist, and they used to say other nasty things, and they would try to hit him and stab him with pencils. I guess being unable to get to me, he was the next best thing. In 1996, the prison officials told me that they received a phone call from the hospital telling them that my grandmother was extremely sick and was not going to make it, and therefore the prison wanted to know that I want to wait until she passed away and then go to the service, but that I instead want to see her while she was alive, yet in a coma, but the price of doing that would be I would have to forego the service. So it was a very difficult decision, because there were many members of my extended family that had never come to see me, and who I knew good and well were never going to come visit me so long as I was in prison. And considering that I was serving a life sentence, and I had already lost a few appeals by that point, this funeral service represented the last clear opportunity I had at that point in my life to see them. So after thinking about it a little bit, I ultimately decided that I would go see my grandmother one last time while she was still alive, yet in the coma. I've always gotten motion sickness, and one of the ways you protect yourself from getting sick from motion sickness is eat before you begin the journey. We left Elmira for Peekskill, that 4-hour trip, early in the morning prior to the population having been served breakfast. The guards were given funds with which to purchase breakfast items for themselves and for me. But while they enjoyed a full complement of breakfast, I was simply provided with a cup of coffee. And as a result of that, I got very, very sick, and they had to stop the car several times because I was on the verge of vomiting. Yet, because I had nothing in my stomach, nothing came out. Which I guess I was fortunate in a way, because considering that I had on handcuffs, I had a chain around my waist, and I couldn't move my hands, and the officers were not willing to loosen that, even though there were 2 of them, and they both had sidearms, and surely I could have posed no threat to them in that position. They weren't willing to loosen any handcuffs, so had I gotten any vomit on my face or on my clothes, I would not have been able to get it off. And I knew good and well, they weren't certainly going to wipe it off. When we got to the hospital, the guards parked as far away from the hospital doors as they possibly could. And keeping in mind that I had on handcuffs, I had a chain around my waist, and my legs were fastened together. So they wanted to be able to parade me through the parking lot to make a spectacle out of me. When we walked inside the hospital, the nurse attendant did a double take at the sight of me. And there was a child with maybe 5 or 6 years old who was running around and playing. The mother kind of looked at me and grabbed the child and brought her close to her, as if I was some sort of violent animal that was going to commit a spontaneous act of violence right there on the spot. Definitely a humiliating situation. When it was time to go, the guards came in the room and informed me that my hour was up. But I looked up at the clock and saw that, in fact, I had 15 more minutes. And so I pointed that out to them, but they insisted it had been an hour, and they forced me to leave. This time, I was given something to eat before the trip. However, the car space where it had been parked at lent itself to the sunlight beaming through the windshield, and so by now, the car had become extremely hot. The guards turned on the air conditioning in the car, but since there was plexiglass fully separating the back of the vehicle from the front, none of it reached me, and they were unwilling to lower the windows even a fraction of an inch. So all told, I suffered for about 8 hours in order to visit my grandmother for less than 1 hour. When my sentence minimum grew close to being over, the prison authorities told me that if I wanted to have any chance at all of making parole, which was already a slimmer than slim possibility as it was, I would have to take and complete the sex offender training program. The problem with completing that program, however, was that there was a guilt admission requirement tied to it. Not only would all the prisoners in the shop be expected to admit guilt to the instructor, but also to the other prisoners in the shop. Simply saying that one was guilty was not enough. They wanted a blow-by-blow description. Then, a verbal rendition wouldn't cut it. It had to be in writing. Failure to complete any aspect of that would result in the prisoner being immediately removed from the shop and to have been deemed to have refused to complete the program. So by this time, I was looking at parole as a potential means of regaining my freedom, and certainly I wanted to do that prior to anyone else in my family passing away. So as you might imagine, I was in a really difficult catch-22 position. In the end, after doing a lot of soul searching, I decided that I was not going to take the program. I couldn't bring myself to give a detailed account of how I committed a crime that I knew that I had not. When I went to the parole board, I knew that they were in the habit of rubber stamp denying parole applications, even from applicants who could demonstrate that they had turned their lives around and been rehabilitated, and that if they were released, they would pose no threat to society. Knowing that that was what the parole board was doing, I tried to protect myself by repeatedly raising the issue of my innocence and referencing the DNA. But they weren't willing to consider even the mere possibility that I was innocent. Towards the end of the parole interview, one of the commissioners asked me a question about an aggression replacement training program that I had taken, and I was able to give him the answer, demonstrating that I had learned the material in the shop. That's when a different commissioner piped up and said, "Well, that's good, Mr. Destovic, because you're going to need those skills once you return back to society. Good luck." The way the process works is they don't inform you their decision right there on the spot, but it's instead mailed via institutional mail, which is received by the prisoner 3 days later. Considering how that interview ended, I actually walked around the prison yard and the prison the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision in the mail, it noted my good educational record, my good disciplinary record. It noted that I had some letters of support from the community. It even referenced a prison employee who had written a recommendation letter for me urging that I be released. But that nonetheless, I had been convicted of a brutal and senseless crime, and to release me, they wrote, would be to lessen its seriousness. They ordered me to serve an additional 2 years before appearing in front of them again for another parole hearing. Now at that point, considering that I knew many prisoners there who were working on years 25 and 30, off of a 15 to life sentence, in which they would go to the parole board, be turned down, reappear in 2 years, get turned down again, and have that cycle continue in a seemingly never-ending cycle of perpetuity, I felt fairly confident in there that I was going to die in prison for a crime that I had not committed. I would like to share with you how it was that I came to be exonerated, proven innocent. While all that was happening, and a lot more that I'm passing over just for the sake of time, I was simultaneously appealing my case throughout the court system. I had the naive thought that the higher up in the court system you got, the more accurate the courts got, but over the course of my next 7 appeals, I would quickly get disabused of that. I went to the appellate division, the first court one must go to, where my primary issues on appeal were my innocence wrapped around various legal arguments, which all tied back to the DNA not matching me, and that my Fifth Amendment rights had been violated by the way in which the police had interrogated me. Even with the threat and false promise not on the record, because the police lied about that, and my lawyer not having allowed me to testify, everything else they did testify to, and it was very, very questionable, to say the least. So those are my primary issues on appeal. The appellate division found nothing wrong with the way I'd been questioned, and furthermore, they wrote that there was overwhelming evidence of guilt. I still don't understand that ruling to this day, because the DNA did not match me. All they had was this confession obtained under highly questionable circumstances. They ruled against me 5-0. Now, from that point forward, although I had 6 more appeals, I never again received a substantive ruling from the court. Let me walk you through this. My lawyer moved to re-argue the case in front of them, arguing that their decision was running contrary to the facts and the law, but the re-argument motion was denied. I went to New York State's highest court, the Court of Appeals, where the procedures you have to get permission from them to appeal prior to them agreeing to hear your case and give a substantive ruling. The Court of Appeals told me that there was no merit in law to justify reviewing my case, and so therefore they were declining to review it. I lost in federal court because the court clerk gave my lawyer the wrong information regarding the filing procedure, and as a result of following that inaccurate information, my paperwork arrived 4 days too late, which former Westchester County District Attorney and New York State Attorney General candidate Jeanine Pirro, who has 2 judge shows on television, her office took the position that those 4 days were somehow prejudicial to the government, and therefore the court should simply rule that I was late without ever getting to my innocence argument. And that's exactly the position that the court adopted. That meant I was time barred, which meant I was no longer allowed to argue my case directly. I was stuck having to argue that the ruling time barring was inaccurate, to try to get that reversed, and then go back to the other federal court to then get a decision on the merits of my case. So I got permission from the United States Court of Appeals to appeal to them on the procedural issue, where the 2 judges who would hear my arguments would be Judge Rosemary Pooler and future United States Supreme Court Justice Sonia Sotomayor. My lawyer presented the following arguments as to why the procedural ruling should be overturned. Firstly, that this was not a delay caused either by me or my attorney, but instead by the court clerk. Legalese aside, sounds like a reasonable enough argument to me. Secondly, she argued that upholding a ruling like that would cause a miscarriage of justice to continue, which kind of in a way brings in the innocence argument and the DNA as a contextual matter. And thirdly, that overturning the procedural ruling would open the door to more sophisticated DNA testing of the type which would go on to clear me 7 years later. Once again, the district attorney opposed, and once again, the court ruled for the district attorney. My lawyer moved to re-argue the case in front of them, requesting that all the judges on the circuit hear the case and make a ruling. That's how strongly she felt that this decision was wrong. But that re-argument motion also was denied. Having no other court left to go to, I had no choice but to apply to the U.S. Supreme Court, which naturally only agrees to hear between 2 to 5% of the total number of matters that come in front of it. And included within that small percentage is a certain amount of civil litigation. So we knew going in that despite compelling reasons of justice as to why they should do so, the odds of the court agreeing to take the case were slim. But again, there was no other court left to go to, so I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the U.S. Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, at that stage, for me to be exonerated and therefore regain my freedom, would be that I would first have to obtain a lawyer who would be willing to take my case for free, or neither I nor my family had any money with which to hire one. And as far as the government was concerned, well, since my appeals were over, that meant I wasn't litigating anymore, so I didn't need a lawyer. So I had to try to find a lawyer to take my case for free. Then I had to try to find an investigator who would also work for free, and hope that in tandem they could somehow find some previously unknown evidence of innocence, without which the court was no longer willing to hear about my case. So my legal work at that point, if we're going to stretch the term and be kind of artsy with it, consisted of writing letters to anyone and everyone I could possibly think of who could help me, either directly or indirectly. If there was a line of reasoning that I could come up with in my mind as to how somebody could help me indirectly, like what action they could take, which could then lead to the next step, which lead to the next step, kind of like a domino effect, which could ultimately result into my obtaining a lawyer. If I could conceive of the theory, I wrote the person. I wrote anyone and everyone you could possibly think of. I wrote large law firms because I had read that such firms often have a pro bono section in it, in which they take cases for free, as I had read it happen in some of the other wrongful conviction cases that ended in exoneration. Very rarely heard back from those firms. When I would hear back from them, they would tell me that they had no time to take my case for free. Although they always made sure before they closed out their letter that they let me know how much money it would take for them to take my case. Then they would, reading between the lines, what they were really saying was, if I would have the money, then they would have the time. Then they would always close out the letter by saying, good luck. Like if I'm going to be okay despite their non-intervention. I wrote reporters, especially those who had written on other wrongful conviction topics, reasoning that their general familiarity with the subject matter might lead them to understand what I was saying when I would write the letter to them. First sentence, Jeff Descovich, I'm innocent, there's a negative DNA test to perform. First sentence is right out the box. And I was hoping that that would catch their attention, lead them to verify my claims, do a little bit of digging around, and maybe write an article or two, and in that way my case could come to the attention of the necessary legal help that I needed. As I had read it happened in a few other cases that ended in exoneration. Only I never heard back from any of them. I contacted churches and other faith-based organizations, reasoning that their belief in God, in whatever form or faith that might take, would cause them to be against injustice and in favor of justice, and by extension, in my behalf. Maybe one of their parishioners was a lawyer or an investigator that they could somehow prevail upon to take my case. Or in the alternative, maybe they would be willing to raise the money that I needed so that I could hire the necessary legal help. Only I never heard back from any of them. Eventually, I wound up in touch with an investigator, Claudia Lippman, who works out of Maine and Colorado. I was actually writing a book author in care of a publishing company, but somebody at the publishing company opened the letter and sent it, instead of sending it to the author, they sent it to this investigator. So she wrote me back right away, and she was skeptical that the DNA test doesn't match you, you're convicted. Yeah, right. Everybody's being exonerated when they have a negative DNA test. So when I offered to send her a copy of my legal brief to prove that, that's when I got her attention. And when she saw it, she instantly became my advocate. She said, your case is too far for me to work on it directly, but I'll help you with the networking. I'll try to connect you with somebody who can directly work on your case. And so we brainstormed together. She gave me ideas. She tried to get people to take my case. One of her ideas proved to be the winning one. She suggested that I write the Innocence Project again, a nonprofit organization out of Manhattan that works to free wrongfully convicted prisoners across the country in those instances in which DNA testing can demonstrate innocence and in which no prior testing had been conducted. I say again because I originally wrote them back in 1992-93. and when DNA was much less sophisticated then as it come to be. As I mentioned to you, their criteria was that they did not want any prior testing to have been conducted. So when I contacted them originally, they didn't know what to do because their method of working on cases involved seeing if there was evidence that could be tested, test the evidence, and then bring the results to the court, arguing that it's newly discovered evidence. That wasn't an option in my case because the DNA was already known. So in a way, if you want to think about it, you might say that I was excluded by the DNA too soon. So since they had never come across a case in which a conviction had resulted despite that DNA test, they didn't know what they could do, and so they passed on my case. Fast forwarding 15 years now, back to Ms. Littman, and she told me that in light of the advancement of DNA technology, that the prior denial was irrelevant. So I wrote them. I filled out their application, and then I forgot about it. I looked for other methods of obtaining legal representation, none of which were successful. Now, I didn't know it then, but I've learned since then that once again, when they received my application, the lawyers at the Innocence Project again did not want to take my case because of the pre-existing DNA exclusion. But every time they said no, one of the intake workers, Maggie Taylor, who was not a lawyer, she would go back to the drawing board and come up with a new theory as to how the DNA could be used and represent my case to them. So she had to do that 3 times. The idea that convinced them that they could try was actually one of the ideas that I had suggested, which was the DNA data bank. So 6 months after writing them, seemingly out of the blue, the Innocence Project contacted me and told me that they were taking my case. So getting their representation was the first most significant event of 3 factors which culminated in my exoneration. The second factor was that the district attorney who had blocked all of my appeals and stopped me from getting further testing, Ms. Pirro, she left office. And her successor had only been in office for about a year and a half. And so, frankly, she was a much smaller public figure than Barry Sheck was at the time. And the third factor, and that meant that she allowed us to have the testing without having to litigate over it. And the third factor was that we got lucky that the actual perpetrator had committed an unrelated crime 3.5 years later when he killed a school teacher, a mother of 2, which resulted in his DNA being put in the data bank so that when I did get the testing, it not only reaffirmed my innocence, but it also identified him. On September 20th, 2006, my conviction was reversed and I was released. I reported back to court November 2nd, 2006, at which point all the charges against me were dismissed on actual innocence grounds. I received an acknowledgement of my innocence from both the prosecutor and the judge, but neither of them were the people who were originally involved in my case, nor were any of the villains in my case that caused what happened to me. Nobody ever apologized. Not any of the police, not the polygraphist, not the prosecutor, not the medical examiner, not my public defender. The only person that was a man, at least in terms of apologizing, right, was the one we least expect out of everybody. The actual perpetrator or murderer who killed 2 people. He was the only one that saw fit to issue an apology for his aspect into what happened to me, in the sense that he remained silent while I was doing time for his crime. So at this time, I want to go to the next slide, which shows when I was released. So if we can back up one slide before that, maybe 2. We'll go one more. Okay, so before. Okay, now we'll go to ahead. After, just so we can understand in human terms what we're talking about. I'd like to share with you a little bit about my life post-exoneration. It's very difficult to put your life back together again after a traumatic experience like that, particularly one that lasted for 16 years. The world was much different when I was released than when it was when I was originally incarcerated. To give some concrete examples, we didn't have internet. The cell phones hadn't been invented. GPS was unheard of. As I walked down the streets of different cities and towns that I knew before. While I saw certain buildings, houses, and structures that I was familiar with, yet some were missing and were replaced with other buildings, houses, and structures. And the people that I once knew that inhabited those streets and those towns and those cities had long since moved away. So those factors, along with the culture being totally different than what I remembered, all of it together, if any of you ever read comic books, okay, I felt like I was in some sort of alternative reality, a world in which I no longer fit in. It was an awkward experience whenever I would meet or spend time with members of my extended family, because although I knew who they were intellectually from having memories of them when I was younger, when there's long gaps of time between interaction with people, the natural growth and evolution as a person, and you become a different person. So when long periods of time have been in between there, it's much more pronounced. And so it was awkward when I would meet them, and I certainly wasn't really able to communicate with them because I knew that nothing in their background would enable them to really understand that I was explaining, something was on my mind of, the trauma of being wrongfully imprisoned, or the being wrongfully convicted, or the difficulties in reintegrating. I couldn't explain that stuff to them because, first of all, they were strangers, and secondly, I knew that there's no way I could really bridge that, communicate that, almost that language barrier. So it was very difficult in terms of that. I was never able to obtain gainful employment. It really wasn't a question of my innocence or guilt. There were some people that questioned that, but by and large, that really wasn't a factor, mainly because the actual criminal was caught, arrested, and convicted. The difficulty centered around a different level of stigma. You were in prison for 16 years wrongfully, yes, but you were there for 16 years. How much of that rubbed off on you? Is it safe to have you around? If I hire you, are there going to be protests outside of my business? How are my workers going to react to having you around? It was very difficult to rebuild a social circle. I was 32 when I was released, but the last time I had been free was when I was 17. So I really was 17 internally. I still wanted to play kickball and go to bumper cars and explore, to do all these energy-based activities. But I knew nobody. Who were my peers? The other people that were my age have passed those stages already and are in a different position in life. The people who were younger that were still about those activities, I don't look like them. I'm an adult. Like, I remind them of a parent. I'm a square, right? I can't possibly be any fun. And on some levels, that's, they don't got the right maturity level. It's not appropriate for me to socialize like that with them anyway. So, very lonely experience is what I'm trying to get at. And that led me to feeling very, very depressed and feeling like I don't fit in, and just feeling, my life is kind of ruined. I would have to go to visit with mental health professionals. I would spend I used to go to therapy 4 hours a week for, I don't even know how many years I did it anymore, in order to get to be the person that you see now. It was very, very difficult. So the next slide that I want to show depicts an example of, no, it's not, is there one before? All right, so, no, you got to go forward. All right, leave it, don't worry, I'll get to that in a minute, it's okay. All right, so it was very difficult trying to put my life back together again. And, just in connection with not being able to obtain gainful employment, one of the things that came from that is, lacking stability of housing. I bounced around from place to place. At one point, I very nearly had to go into a homeless shelter. I was not above putting cereal in a bowl and putting it in my backpack and carrying it with me if I had to go to the city to see my lawyers or to see one of the mental health professionals, because I couldn't afford to eat out. The only employment I was able to get was as a weekly columnist. But although they were paying $250 an article, which is great money to do that, it was a weekly newspaper. So all they wanted was one article a week. That was the only way I had open to me to make money. But I was making some money doing presentations, but that's almost like being an actor or a performer. If you don't get booked, you don't make money. So I had to try to squeeze by with $1,000 a month. Thank God that Mercy College intervened when they did, because other than them extending their scholarship, which already included the meal plan, the books, everything, they allowed me to stay in their dorms for 6 months, for free. Other than that, I would have been into the homeless shelter. And when my term was up there and I graduated, Human Development Services of Westchester at that point entered my life, and they were a nonprofit, and I just, by coincidence, I happened to fit their mental health criteria of people that they would serve because of my diagnosis. And so what they would do is they would rent apartments to their clients, and their clients would have to give them 30% of whatever they made in the course of the month, even if that was nothing. Other than that, I would have been into the shelter again. So that was really my existence for about 5 years. So you might say I experienced, I was traumatized again. I went from one difficult situation to another, totally unlike what I thought the life I was going to have. And I was daydreaming about being free when I was in prison. I thought that I would live in an area where I wanted to live. I thought I would have some sort of gainful employment, doing something meaningful that I wanted to do. And I thought that my salary was going to be at the same level as it would have been had my life not been disrupted, because the people would have understood what happened. And, that would have been something given to me in consideration of that. And when I used to daydream about wanting to go to the movies or go here or go there, these different things I would see on TV, I never stopped and thought, there's a financial aspect to that. And by the way, Jeff, you're really going to have people to go with you. All these factors never really dawned on me. I thought that I would be helped right away by the government, and it was their moral responsibility to do that. And I thought that I was, going to be provided with, housing, cost of living expenses, doctor and dental care, mental health professionals, job training, job placement, help with technology. It was the state's obligation, after all, that this happened to me. They should help reintegrate me. But I was disabused of that right away. No help was forthcoming at all, ever, to me or to anyone else into my position. New York State has a compensation law in which I could file a lawsuit and seek compensation in the state court and the federal court. But I was unclear as to what the process of that was, and I was still incarcerated wrongfully. I thought that was a very short turnaround. I mean, if you already proven innocent and the criminal court recognized that, well, it should be a very fast, simple, and easy thing to be compensated. It's already been established in court. Why else would they let you out? But I learned that's not how it worked. You had to file a lawsuit, and it takes between 3 to 7 years on average. For me, it took me 5 years living like I told you before I was finally compensated, and another 3 before I got to have a trial, because I sued everyone that was involved. I filed a lawsuit in state court. I was compensated there after 5 years, and I filed a civil rights lawsuit. I filed against all these defendants. The county, because of the fraud for their medical examiner, and they settled with me. And another defendant was Peekskill, because they coerced a confession out of me. And when they interviewed 17 witnesses who knew the victim in one capacity or another, they went into the field. They spoke to people. Once the DNA didn't match it, they were looking for evidence to support this false consensual sex theory. So they interviewed 17 witnesses who knew the victim in one way or another. They all told the police she had no boyfriend. There was no consensual sex. But what the police did was they never documented any of those interviews, and as a result of that, there were no police reports to turn over to me. My lawyers could have made use of that at the trial. It could have had a different outcome, but they didn't do that. They didn't follow the procedure. And so I held them to account for that. It was Legal Aid Society, because it was their lawyer who provided deficient representation. There was a note in the legal aid file where he put a note in, genius that he was, he put a note in the file memorializing that I told him about my alibi, who he was, and to go speak to him. And it was also clear from the file, he never spoke to him. So they settled with me. And then I also went, then the last one was the polygraph, Daniel Stevens, who I sued Putnam County because of his hand, because until he stepped in, the police were unable to get the confession on their own. And so he stepped in and carried out what he termed GTC, get the confession. And if he didn't help the police arrest me, the prosecutorial misconduct couldn't have happened. The fraud by the medical examiner couldn't have happened. And I wouldn't have had a case to defend where the legal aid lawyer did a terrible job. So I considered him to be the most morally culpable of them all. And so I went to trial with him. I wanted him to have his lawyer, let him present his evidence. I'll have my lawyer present my evidence. Let's have it out in front of the jury. Let's see who an objective body, who they believe. Give him a chance to, defend himself. So the jury didn't realize that I had an agreement in place with them in which if I won, they would have to pay not more than a certain amount. And if they won, they wouldn't be allowed to pay less than a certain amount. So the jury didn't realize that there was that deal in place. And so the purpose of the trial was just to determine which figure they were going to pay. The jury didn't know that. They thought that whatever award they got, they awarded would be what it was, right? Unless it was reversed on appeal. So as an expression of their outrage at what had happened, they came back with a $41,161,000 verdict. That's how bad they said that what he did. Obviously, that's not what I got. I had to deal, but I don't have buyer's remorse at all because nobody actually collects a verdict like that. Okay, just so everyone's clear. And by the time everything had gotten, reduced and everything else, I would have likely ended up with less than what the deal was. So I don't regret that decision for a minute. I'm just trying to share with you, give you a barometer with which to measure the injustice that has happened to me, as seen by those 6 jurors who saw all the evidence and heard me testify, heard him testify. When I was released from prison, I went to the press conference and I was kind of surprised. I wasn't thinking about what to say to the media. And so I gave my first words. Firstly, my first words were, is this really happening? So I couldn't believe that I was actually, had been released. And from there, everything I'd ever wanted to say, but I never was able to get anybody to hear, it all came to me. And so just as I thought I was wrapping up, another topic came to my head, and then another, and then another. And before I was all said and done, I had spoken for 2.5 hours off-the-cuff presentation. And it was at that moment as I left there to go to the luncheon, it was then that I realized I could be part of the innocence movement without necessarily being a lawyer. And so I began an advocacy career. I began doing presentations and doing meeting interviews, basically having made a decision to trade privacy on all these issues. Trade privacy in exchange for awareness, hoping that that will pave the way for changes to happen in the system to prevent this from happening to other people. I began meeting with the elected officials and testifying in public hearings. I was the columnist and it became kind of like a quasi-public persona. So after about 5 years of doing this, and by the way, at the same time struggling, all these struggles that I mentioned before were happening at the same time that I was doing all this advocacy work, all the financial and every other struggle at the same time, still finding the time for my formal education, the bachelor's and then the master's at John Jay. At the end of the 5 years when I was compensated, I decided that I wanted to take my advocacy work to the next level. I wanted to do things that I could never do as an individual advocate. I wanted to continue to do the policy work and the awareness, yes, more of same basically, but with a support team. But more importantly, I wanted to be able to exonerate other people. I wanted to reach back out into the prison system for some of the men and women that I metaphorically left behind, whose names I might not have known, but whose existence I was absolutely certain of. And so I took $1.5 million from what I received, and I started the organization named after me, the Jeffrey Descovich Foundation for Justice. And this is our opening day. If we could just dim the lights for a second. This is opening day, our first day. You see I have the decal, there I am. Fernando Bermudez to my right, Mr. Exoneree from New York, who did 18 years wrongfully. To my left, Jabbar Collins, who did 16 years. To his left, Raymond Santana of the Central Park 5 fame. A couple of my board members at that time, Rosemarie DiGuglielmo, whose son is still wrongfully in prison, an off-duty police officer who shot and killed a bat-wielding assailant that had struck the father in the leg with a bat, broke his wrist on the second try, and was swinging for the head when the off-duty cop shot and killed him. Yet he was self-defense, but yet they convicted him on a racially motivated homicide, although not one person ever testified that a racial statement was ever uttered. So her and then Anne Marie DeSimone, right next to Mr. Bermudez, who was the layperson advocate who was really the main mover and shaker in her husband's case, which ultimately resulted in a reversal based on exculpatory material being withheld. So those are the people there on the board. Like the other person to my right was the then assistant director of the organization, Richard Glassberg. So I started the organization, and let me get into my motivations there with that. Why would I start an organization? Well, it's rare it happened to you after all, Jeff. It's not rare it happened to me. I wish that it was. Let me get into the frequency here as I change gears a little bit in this presentation. Let me give some context as to how frequently this happened. This past year, I believe the number is 166 people who were exonerated in the last year. Give or take a couple of numbers, but that's the general ballpark. The year before that, it was 140-something. The year before that, 130-something. And the 2 years before that, 91 and 91. I used to know the exact figures. It just part of my experience just wanted a number. That's the range. That's the people that made it out. That's the people that were exonerated. To give further context, there's a University of Ohio study that estimates that 10,000 people are wrongfully convicted each year. There's other online publications which estimate that right now between 50,000 to 120,000 people are wrongfully imprisoned across the country. In Brooklyn, where there was a change in regime, and where the district attorney who had been in office for 23 years was beaten in a primary by a challenger who ran on a wrongful conviction plank. And so with his defeat and a new district attorney in office, he set up a real conviction review unit, as a result of which 23 people were exonerated in 2.5 years, who would have never seen the light of day had the old DA still been in office. But that's not the only place. That's just one example where a long-serving DA helped to suppress. If we were to, for other district attorneys were to be removed from other places, how many more people would be exonerated? So I also think about other factors. When I think about how every time there's a rogue police officer, how many cases could be affected. In Brooklyn again, going back to that spot, disgraced former detective Louis Scarcella, who it came to light, there was 6 different homicides, 6 different murder cases, where he used the same drug addict as the sole eyewitness to 6 different murders. What are the odds that one person's going to witness 6 crimes? Then his confession cases came under scrutiny. Seemingly everybody says to him to begin, okay, you got me. So depending on which newspaper account you read, 40, 50, 70, 90 cases of his are under review. There's just one rogue officer, but he's not the only one. Every time there's a junk science that is exposed as such, things that used to go as evidence in courtrooms that had like an air of science being scientific, but actually aren't scientific at all. Things like fingerprint evidence, where there's not really a consensus on how many points of match there have to be in order to constitute a match. Things like bullet lead analysis, where the FBI sent experts into the courtroom to give expert testimony for 20 years, while at the same time internally acknowledging that it's not a science at all. There's nothing scientific about it. You can't actually tell from the chemical composition of the bullets, where the bullets were actually produced at in order to try to trace it back. Things like tire tracks, footprints, bite mark evidence. My favorite, which would be laughable, except that it's had terrible results, dog scent testimony, where we're going to give an item to the dog to smell, and then an item from the victim at a crime scene, and then if the dog barks, then that means he recognized the smell. Again, it would have been laughable, except that people, this went on for like a decade in Texas, followed by another decade in Florida. When you think of all these factors, you think about forensic fraud, where dry labbing is the key term to remember, dry labbing. So from science class, if you remember how to make a wet mount, you put a little bit of water on the slide and look at it under a microscope. So it's called dry labbing because you don't need the water. Because you're not doing any testing. You're just going to write something up in favor of the prosecution instead of ground level science. One person that can affect hundreds of cases. So this has gone on, for decades. So all of that, and the fact that 13 people that I personally did time with in the course of my 16 years that were exonerated, either before me or after me, that all leads me to this point that I think that the percentage of wrongfully convicted prisoners, I think it's 15 to 20%. So what is it that causes these wrongful convictions? Because I don't tell the story just to tell the story. Okay, there's a point to it. What is it that causes the wrongful convictions? Well, coerced false confessions, where there's been a cause of wrongful convictions in 25% of the cases, where the obvious remedy is just record the interrogation, allow false confession experts to testify. And by the way, on the topic of false confessions, since you all are about the age that I was, you should know what to do if the police want to question you. If the police want to question you, give your name and your address, and the third thing you're supposed to say is, I want a lawyer. There's nothing they need to speak to you about that's so urgent that can't wait for them to give you a lawyer which will level the playing field and take it from there. The innocence of suspects, people that police question, often works against them because they think, well, what's the harm that could come if I speak to the police and I didn't do anything, I don't know anything about a crime? But actually, quite a lot can happen, and you can see that here with me today. We need better identification procedures. That's going to cause a wrongful convictions in 75% of the cases. Prosecutorial misconduct, a huge cause of wrongful conviction. That's a common thread that runs through almost all the cases. Prosecutors, they have immunity. So no matter how terrible it is, they can withhold evidence of innocence. They can threaten witnesses to charge them with crimes, or they can threaten parents to remove kids from their custody if they don't give the testimony they want. And they can work hand in glove with experts, like I told you. And if it happens after an arrest has been made, then they have immunity. You're not allowed to sue them. You can't hold them accountable civilly. And they also don't face any criminal penalties. And there's no oversight. So I think that there should be oversight. I think there should be a commission on prosecutor conduct. I think that we should remove immunity. Police officers and forensic scientists and no one else has this immunity. If you run over someone's constitutional rights, you're subjected to a lawsuit. That's what you should be. Why should they be above the law? There's nothing to restrain them. And to me, if you withhold evidence of innocence and that results in a wrongful conviction, then that's a kidnapping to me. That was done under color of law. And I believe strongly that should have incarcerated penalties attached to it. We need to have corroboration when it comes to informants. Do you know all it would take for you to be charged with something would be one person to point a finger at you? Don't even say that they saw you do something. All they have to do is say, oh, you confessed to them, that you had a conversation with them. And that is all that's actually needed to arrest you. So I think that as a safeguard against that there should be a requirement that there's at least one other piece of evidence in order to go with that. And that these so-called jailhouse confessions where people who know each other for weeks or short months seemingly freely discuss committing serious crimes with each other as if it's nothing. Let them wear a wire if they want to be an informant and try to cut a deal. So we can be sure that these conversations happen as opposed to just being made up. It's not very hard to make a story up like that. Learn about a case, just read it in a newspaper, get a few details, throw a story together. Boom, that's it. And people have done that to others. That's the cause of wrongful convictions in 15% of the cases. Sometimes the lying informant was the actual person who committed the crime. Isn't that ironic? But all these deficiencies, the deficiency of not having a standardized evidence preservation system in place, what that means is this. If you're lucky enough to have been wrongfully convicted in the case where DNA is available, well, let's all be clear, that's only in 5 to 12% of the total number of cases that exist. So if you're lucky enough to have been wrongfully convicted in one of those cases, the next obstacle is whether or not the evidence has been lost or whether it's been destroyed. Most states don't have that law requiring to be the preservation. And so if it's been destroyed, you just would be stuck in prison, unable to prove your innocence through that. So I think that all these changes in the law need to be enacted so that we can prevent future wrongful convictions. Because I think as a society, as great as DNA is, and I'm only here because of it, I think it's lulled us into a false sense of security. We think it can't happen now because we're so much more enlightened than there's DNA. But if it's only available in at most 12% of the cases, and all these other deficiencies that have caused wrongful convictions in the past, if these deficiencies haven't been changed, then that means people can be wrongfully convicted just as easily now as they have been in the past. We need the judges to take a better role, particularly on the post-conviction level. Part of the problem in why these wrongful convictions last as long as they do is that the judges rubber stamp deny a lot of these appeals. Often it doesn't matter if you got the law or the facts on your side. You know, they look at themselves as an extension of law enforcement, whose job it is to protect the public by upholding convictions however they can. But that results in claims not being objectively decided, and that means that some innocent people like myself are going to suffer the upholding of a conviction when that's not warranted. The average length of wrongful imprisonment is 14 years, and typically most people have had their appeals long since exhausted by the time that they are exonerated. And that's the reason. Elevating procedures above innocence. Can you think about what I told you earlier? Do you really believe, I'm beside myself right now, just thinking again about it. Can you believe that the court thought that my being 4 days late was more important than whether my argument that I was innocent or not had merit? Can you believe that? Forget about the court misinformation. Even if there was no misinformation, you really think something being 4 days late, that's how a case should be decided? I understand there's standards that have to be upheld, but that should be a sanction on the lawyer. What was I supposed to do? I'm in prison. I don't have a law degree. I only know the little bit I know about the law from going to the law library. A lot of other people don't even know that. So if a lawyer files, I have no control over the lawyer, so if a lawyer files late, that's a sanction you take up with the lawyer. But to dismiss a case based on that, that's just so far beyond the pale of justice. That's like guilt innocence doesn't even matter anymore. And we need to have a change in that. So in the 4.5 years of my organization's existence, we were able to exonerate a couple of people. One of the more meaningful moments of my life beyond my own exoneration, I'm hoping that we have the slides on that. So let's go to another slide. We have another one. Yes, we do. We do have another slide. All right, so that's my friend William Lopez. This is our first exoneree. We toasted him last night in the meal. Myself and other guests, I'll be calling up in a few minutes. A couple of other people that went to dinner with me. So Mr. Lopez was exonerated after 23.5 years. It was a shotgun murder in Brooklyn. My foundation, we got involved in this case during the last year of his wrongful imprisonment. Long story short, it was a shotgun murder. And right away, it was clear from everyone right away that he was innocent. The witness testified that the two perpetrators who committed the crime were 6 feet, 6'1", and he's 5'7". Okay, I'm 5'10", and you can see I tower over him somewhat. Criminals were described as dark-skinned Panamanians, and he's light-skinned Puerto Rican. The weight estimation, the perpetrators were estimated to be 100 pounds more than what he was. It started out as a two-witness case. One of the witnesses could not make an in-court identification. The other one was a drug addict who had been up for 24 hours, having done 12 vials of cocaine, who had actually got a deal for her testimony. She claimed she wasn't getting a deal, but miraculously they let her out of jail the day after he was found guilty. Okay? So and then his lawyers were terrible. They talked him out of presenting his two alibi witnesses. So he was in for 23.5 years. We exonerated him. We helped him reintegrate. We keep his memory alive today. We talk about his story. We talk about him. He passed, by the way. He was out for a year and a half after his 23.5 years. Moving to the next slide. William Hawley, to the left, who's dressed a little bit better than me, is our second person that we exonerated. He was in for 8 years and 4 months on an arson case that actually was an electrical fire. That exoneration that took years to win happened about 7 months ago. So I have a dream. You know, my dream is this: is that what if we? And let's go to the next slide. What if we had? What if the organization? What if we had 25,000 people who thought that it was worth giving up $3 or $5, $1.25 if it's $5, $3, you divide, do the math, it's 4 weeks. What if there were 25,000 people who were willing to sacrifice that little bit of money, but on a recurring monthly basis, every month, so that the foundation, so that we could increase our budget? With that money, you know what we could do with that? We could hire, and I have it all on this website, patreon.com. We could hire 2 lawyers. We could get 3 investigators. We could get 3 paralegals. We could have someone to oversee the day-to-day operations of it. We could have someone to work in fundraising. We could have an administrative assistant. There'd be some cash left over to hold some gala dinners to raise more money to. Because we've been doing the work we've done on a shoestring budget, on what I was able to contribute from the money that I told you that I parted with. But I can't keep writing a check every month to continue to do that. And we need to increase our donor base. And so the purpose of me bringing this up in the context of this presentation here is this. In order to make that happen, and I really believe I can make that, it can be done. Not that I can make it happen, but that it could be done. Okay? I need help. I need as many people as possibly can, using every method under the sun, as long as it's not illegal or unethical. Help me make that campaign go viral. I got to get out of my network, and we got to get into, 10, 12, 20, 30 people's network, and then it goes from there, and it takes on a life of its own. And if we can do that, we can get the budget I'm asking, we can go beyond that, and we can get even more people out than what we've been able to do so far. And so as I wrap up my presentation, there's 2 points I'm going to make. So the first one is, in terms of deciding whether this campaign is something that you want to get involved with, and Mr. Hamilton will be the point person on that, the liaison, or whether this is just going to be the memorable moment where the guy who did the 16 years came to the school, and you talk about it for a day or two, and you forget, and maybe reflect back on it a year or two from now for a couple of minutes, and then it's gone. As opposed to it being that, or a moment that leads to you contributing in your own way to something very, very meaningful that could lead to even more people being free. Think about this. I was not a high school dropout. I was actually on my way to school when this happened. I had never been arrested for anything, not even a violation. None of my friends were involved in crime. It happened to me. And it could happen to you, your daughter, your neighbor, your best friend. I ask everybody to help me because this is an issue that everyone in society has a stake in. Every time the wrong person is convicted, that means a criminal is left free to strike again. So in a larger scheme, yes, when you send the wrong person to prison, it's terrible. It affects them, it impacts their family, all true. But in a larger sense, it also leaves society very vulnerable because the actual criminal could kill somebody else, could commit another crime. That happened in my case. It happened in plenty of other cases. So I really ask your help in this to, continue the fight. None of the money makes its way to my pocket. I work maybe 50 hours a week. I don't get paid. It's something that is meaningful to me. I'm in law school because I want to try to handle a few of the cases myself. But even in that scenario, there's only so many I can do myself. We really need a lot of people to go at this. I need many minds, the help of a lot of people. They can't work for free. That's just the bottom line. So they need to be paid something to make ends meet to try to get people out. That's why I need the help. Maybe the last point and I promise I'll wrap up with this, is I want to speak to capital punishment for a half second, because I know that that's really a big issue here in California. There's been several repeal measures on the ballot in recent years where in closed votes, the decision by the public in the referendum was to keep the death penalty. So I want to just weigh in briefly on that. When I think about my case, and if I had been 18 rather than 16 and everything else played out as is, the factors that were in my case are typically the factors that would be in a capital murder case. The prosecution decided if it's going to be a death penalty eligible case or not. First of all, there was the rape along with the murder. That's often an aggravating circumstance. Secondly, there was community outrage. I mean, the whole city was against it. So those are the main factors. So imagine if I had been 18 and it had been a death penalty. So I don't have too much doubt as to what my sentence would have been. My appeals were over in 2001. You know I was exonerated in 2006. So if I had been sentenced to death, I would have been executed. I would have been alive to have been cleared. Additional reasons to think about, though, the fiscal reason. I mean, in New York, from 95 to 2004, we had a death penalty. Nobody was executed. Thank God for that, by the way, but it wasn't used. But $200 million was spent on that system. Imagine if the money had went to social programs, crime prevention, other worthy ways that could have been spent. A lot of murder victim family members say that the death penalty, it re-victimizes them because every time there's an appeal, which is necessary, by the way, obviously, but there's a lot of publicity, and so the scabs get ripped off the wound again. I think that morally it lowers us as a society. I think it lowers us down to the level of someone who committed the murder in the first place. I don't think it makes any sense to kill people who kill in order to show that killing is wrong. It's kind of a circular argument to me. And then on top of that, it doesn't deter. States that have the highest murder rate have the death penalty. And in fact, there's a phenomenon which is called brutalization, which basically, when someone is executed, there's often a spike in murders in that state. So not only does it not deter, but it actually makes things it makes things worse. So with that, I'm gonna close out. I'm gonna thank everybody for listening to me, and thanks for listening. I'm gonna invite the next speaker up, but I want to thank you as far as my part of this today before Q&A. Thank you very much. So at this time, I'm going to ask the next speaker to come up. He's a fellow New Yorker. So Anthony DiPippo is with us. He'll come up to the stage now. And just in terms of Anthony, Anthony served 20 years in prison. He was actually wrongfully convicted not once but twice. He recently went back to trial where he was acquitted in trial, but he was finally allowed to present evidence of the actual perpetrator, a serial rapist. He was acquitted. He's got so much heart. How many people would go to trial a third time after having been wrongfully convicted twice? He didn't take a guilty plea in order to secure his freedom. He wanted exoneration. He braved another trial. And I'm so happy that he's here with me. He flew out here from New York with me to do this presentation and to go to the Innocence Network conference. Can we all please welcome Anthony DiPippo?
Is this working? You got this on? On October 11th, 2016, I was released from prison after having served 20 years for a crime I did not commit. The details were horrid. It was the rape and murder of a 12-year-old girl. Her body was found in the woods. I do have to tell a little graphic, trying to keep it PG. A rope was attached for her remains, which will be critical in a moment. How I came to be falsely accused: an individual named Dominic Neglia, who was an informant for the police, had given the police 3 names because he made a deal with his drug charges, and they beat him up. They were paying him. And so he falsely identified people he knew me to be associated with. He named Denise, Adam, and Bill. So police, obviously, they go to Denise first. We have evidence that puts you into a murder investigation. And if you don't cooperate, you're going to go to prison too with him. So after 3 weeks, she gave the police a story that was completely fabricated, which included the 2 other individuals that were falsely identified by the informant. A month later, they went to the next guy, Adam, the same guy that had taken Jeff's lie detector test, Daniel Stevens, gave a lie detector test to my friend Adam and told him he failed, and they got him to give a statement, which he had recanted the next day. Recantation is he takes it back and says it was untrue. Finally, they went to Bill McGregor. He said he was asleep when the crime occurred and woke up at his house. Now, he also recanted. Denise did not recant. I went to trial. I blew 1997. I filed about 20 appeals. Finally, 2016, I got a reversal. The individual who had actually perpetrated the crime was represented by my trial attorney, which created a conflict of interest. This individual had confessed. He was last seen with the victim. The woman that saw him identified him in a photo array as number 2, said he had a red car with Connecticut license plates. And he had this modus operandi of abducting people and using assault. So I get to the pre-trial, 2012, I said 2016, 2012 I won my first pre-trial based on the proof of this guy, Gombert's guilt. They told me I could not present any evidence whatsoever about Howard Gombert, even though the appellate division reversed my case on the basis of such proof. So now, I have to go another 4 more years. Now that's the second trial. Now I won a third trial. The court says the proof was admissible, and they denied my constitutional right to present a defense. Gombert's declarations against penal interest, in other words, his confession or admission of guilt, were supported by evidence independent of the statements themselves that tested their trustworthiness and reliability. And so I go to the court. I actually make bail. Then I posted some stuff on Facebook. The district attorney didn't like it, put me back in jail. 42 days later, I had a trial and I was acquitted. 11-1, the jury closed the door, went in the back room. It was 11-1. They were gonna, they wanted to quit me. There was one guy that wanted to ask a few questions and it took him about 5 hours to come around. And so I was free. And Jeffrey Deskovic was there and gave me a big hug. He's been my hero ever since. I like doing these things with him, not for me, but for you. I try to help educate. The 2 points that I'm making, I'm going to spin off, is one, be careful. If you want a career in law enforcement, if you want to be a law enforcement officer, a cop, a correction guard, you should always be cautious of what informants tell you, especially when they're trying to make a deal for themselves, because they do falsely accuse other people. And secondly, like Jeff had said, when the wrong person is incarcerated, the true person remains at large to commit further crimes. And in my case, the individual committed several crimes against women and children, including killing other people. And with that said, I hope you enjoyed our presentation. I'm not as good as a speaker as Jeff, but God bless you.